is a person, he is belonging to SCBC category, and the category number, the SCBC candidates are more than 5 times. But in respect of the other categories, no, it is not there.
But there are 4 petitioners.
The senior panel consider in presidential submits, when Bingley submits, that the writ court should look into not only the infraction of the norms may be enacted in the rules or in the recruitment notification, but the actual prejudice suffered by the candidate who was permitted to participate in the proceedings in a wholesale basis. Even otherwise, individual prejudice, as between individual prejudice and the prejudice to the public interest, which the commission advocates, the latter should be kept in view. He adds that no prejudice whatsoever is caused to petition at all. Merely because the zone of consideration arguably has not been reduced by adopting preliminary examination. That's your stance.
My lord, my reply, my lord. Prejudice has been caused, and how it has been caused, I will now demonstrate before lordship. Your lords may kindly see para 14 of their first counter reply. There they have given a category-wise breakup of the candidates to justify their decision. Your lords may kindly mark. But I am confined to Hindi teacher. Since we are concerned with Hindi teacher, we are not concerned about other category. Your lords may kindly see yours, ACBC, SC and ST. And the total number of advertised vacancies you are seeing, number of valid applications you are seeing. Your lordship is seeing, my lord. Now, my lord, your lordship may kindly see, kindly come to this observation of the Honorable Apex Court in para 4 in the Constitutional Bench judgment of R.K. Saural. Para 4 I have outlined, your lords may kindly mark. And then kindly see whether this affidavit is correct in law or it is misconceived. Your lords may kindly see this paragraph. Because the entire UR post is available even for a ST candidate to be considered, SC candidate to be considered. You cannot bring it like this. Thereby you are compartmentalizing reservation, which is not permissible. A UR category candidate cannot be considered against the reserve category post. But reserve category candidates can very well be considered. So while calculating it, how can you compartmentalize this same and decide whether it is 5 times or not?
Sabharwal, why that R.K. Sabharwal?
Yes, R.K. Sabharwal.
How that comes to be?
My lord, here, my lord, your lords may time.
Sabharwal says,
yes,
in respect of unreserved category, reserved candidate can compete. In respect of reserved category, unreserved candidate cannot compete.
Now your lords may kindly come to this table. Para 14. In order to justify this, they say less than 5 times they have taken only your category candidates to calculate this. Whereas all the candidates in the fray are required to be considered for your category posts. And your lords may kindly mark. Again, my lord, I will take your lordships to that stipulation in para 4. Para 4 says, your lords may kindly come to, on my request, your lords may.
What is ground?
Just a minute, please. Page 24. Page 24. My lord may kindly come to page 24. This is my last endeavor before lordships to harp upon. My lord, this may sounds to be a reiteration. Your lords may kindly come to the very plan of examination as prescribed.
And pattern of examination.
Yes, my lord.
Yes.
My lord, my learned senior said, my learned friend appearing for the commission said, the entire words, the 3 sentences are to be used conjunctively. It should not be read in
He said it is not a rule It is only one remark. Therefore, it should be interpreted with common parlance, not like a statute.
No, he says all the three sentences are to be read
Harmoniously.
in tandem.
Absolutely.
In tandem. Your Lords may kindly see, this submission is misconceived, reason being, the first line itself says regarding preliminary examination, and the second line says based on the marks obtained in the preliminary examination.
It is a stage-wise.
Stage-wise. So this is one
Question of a harmonious construction will not arise.
Be obliged. My lord, now your lords may kindly see the real catch. It says, my lord, based on the marks obtained in the preliminary examination, approximately 5 times the number of candidates will be shortlisted post-wise and category-wise. Here, my lord, your lords may kindly see what should have been the position. My lord, had this second line been interpreted correctly and adopted, then the situation would have been as against, now you lords may kindly come to the very same paragraph 14 where the table. The table. As against SCBC candidate 40 total advertised vacancy 80, total candidate who would have been participated in the written test is only 400. Instead, how many have appeared? 2,943. You lords may kindly see. This itself prejudiced and violates the condition of the advertisement once again. This power they do not have. Moreover, your lordship may kindly see, I am deeply obliged because your lordship have repeatedly posed that question. My lord, the very same the resolution of the government only empowers the commission that 94, that resolution today given in course of additional affidavit, that only empowers the commission to adopt shortlisting. That power itself was utilized by the commission or exercised by the commission prior to issuance of the advertisement itself. And once that advertisement was issued and a detailed procedure has been delineated thereby, question of further relaxation, even if available under the rules, doesn't arise. Because that is a stage which has already gone. And you lords may kindly see the prejudice clause they are saying, and they are saying on us there was a duty to send up 5 times the number of candidates in each category. Let us suppose in a given case there will be no candidate who had applied. Where from the commission will get? Suppose in a situation, my lord, I am giving an example to myself subject to your lordship's acceptance. Let us in the preliminary examination, out of 4,493 candidates who would have been allowed to appear at the written preliminary examination, only 300 would have qualified because the examination is qualifying in nature. Your lordship have seen the examination of preliminary is qualifying nature. Only 300 candidates belonging to SC, the few SC, few ST, few SCBC and the few UR category candidates who would have qualified. Where from the commission of times. They say as if a duty is cast upon them to collect these 5 times of the number of advertised vacancy to set up for the written test. Where from that? Because of that is why the preliminary examination. The persons who you lords my learned senior showed the syllabus relating to pedagogy. My learned senior had not shown the syllabus which has been prescribed relating to that preliminary examination in the advertisement itself. The advertisement itself, page 25, has prescribed the syllabus for preliminary examination. You lords may kindly see.
Go to 20.
Page 25.
You can go on turning the pages for another 5 minutes.
No, my lord. Sorry. My lord may kindly see page 25. Indicative syllabus for preliminary examination. General studies, arithmetic, logical reasoning, computer, internet awareness, current events. So, cunningly for Hindi teachers post, while holding this examination for PGT, Arts, Science and some of the teachers, they ignored it. Reason being, your lordsman knows my lord, what would be the fate of these people. So they have avoided this. In order to avoid this, they have decided these few categories of people who will not appear at the preliminary examination. My lord, now one thing they say, we have taken a conscious decision or uniform decision in respect of 5 posts. Though we have held the examination in respect of other 4. The question is, those persons are not vigilant. Can a wrong make another it? When being vigilant, I am Hindi teacher the category post. I am abreast of my right. I am before your lordships, and this honorable court has protected the entire selection process from being culminated into any result. But question of all these things, we have followed a uniform policy. Certainly should not stand on the way. The reason being, you have done wrong. They have not challenged. The selection process you have completed. Well and good.
That they have not come to court, or you have come to court?
Yes, actually, in my case, I have to be considered. My humble submission before lordships, the Tej Pathak case, my Lord Senior has said only the conclusion part. My Lord Senior said it is only in case of eligibility, but
Qualification and eligibility, but in respect of mode of examination, mode of recruitment, this is continued.
He says that eligibility, the rule of game principle will apply only in case of eligibility
And qualification.
not in case of procedure. You must make kindly the conclusion and not
In the same judgment.
same judgment.
One second, I'll read that way.
Then you must make
He read para 54, 55, 56 para.
it is in part 54. Well, 4 to 15. I have this just kindly. It will be easier on your part, lordship's part to just see it because I don't want to kill your lordship's time.
I have already filled.
He has argued well. Yes. For any joke, for humor, you can take that step.
My lord, may kindly see this. I have just marked for your lordships.
No, which paragraph? He says I am holding that judgment.
Yes, this is from Manupatra. That is why I am pointing out. This is from Manupatra.
How the sentence begins?
Yes, my lord. Conclusion. It's a conclusion.
Yes, here, 65. Why don't you answer the reference?
Yes.
Kindly give it to him.
My lord,
I don't want to get confused with other
yes. Your lords may kindly see the conclusion.
eligibility criteria.
4.5.
5. They change.
Recruiting bodies. My lord, start with
Recruiting bodies.
recruiting bodies subject to extant rule may devise appropriate procedure for bringing the recruitment process to its logical
End.
and provided the procedure so adopted is transparent, non-discriminatory, non-arbitrary and a rational nexus to the objects to be achieved. So the procedure is there. Second, my lord, the extant rules having statutory force are binding on the recruiting body both in terms of procedure and eligibility. So my lord,
There is rules.
so my Lord Senior is wrong in saying that the Honorable Supreme Court has not dealt with the procedure because the more is that you have the lordship.
That sentence you did not read.
Yes, 65.5.
Placement of the select list gives
Non-extant rules.
However, where the rules are
Yes,
non-existent,
yes, non-existent or silent administrative instructions may fill the gap. Here, my lord, there is an administrative instruction which authorizes the commission only to shortlist, not relax any procedure after it is prescribed in the advertisement. There lies the distinction between the two. Once you have utilized that to prescribe the procedure in the advertisement itself, you are bound to follow it meticulously till the end. Question of its violation, relaxation, when such a provision is not available in the advertisement itself is not permissible.
My lord, only one clarification.
Just a minute.
my senior used to say,
Yes, sir.
once I asked him, sir, how long I should argue before the judge? He said, till cows come back.
Sir, gotte line. You're also only one line. In the tentative merit list, the tentative result which they are showing, you also make kindly mark. There is a catch. Your also will find that tentative result, whatever was answer key was published, that was not final. You also may kindly see for it is relating to 130.
130.
130. You must kindly mark the top. Here it has been mentioned that it is only the answer key itself is tentative, it is not final. Just a minute.
But the answer key,
That is not final.
the answer key, he knows about his position.
Second thing,
He will not be successful. Therefore, he turned around and filed this recompense.
this is I don't second thing is
Yeah.
there might be the notice itself gives option to candidates whether to opt for it or not. Not the answer key which has been provided is final for all purposes. That also commission is not saying. So these interveners who do not have legs to stand because there is no list prepared, no they are saying we are stopped because it has been published. So that the list itself being tentative, it has got no binding and it is variable from the very notification itself. That is what my submission is.
Very.
Oh,
All argued very well. With that,
My lord.
Yeah.
May I mention?
My lord.
Mention number 58. That non-supply of certified copies, your lordship had issued emergent notice. This mail was directed in the instruction that why this certified copy